Hi, I'm Laura Carmichael, the Executive Director of the Autism Alliance of Northeastern New York. Thank you for joining us tonight. And thank you, Hipaa Provost, for putting the series together. She organized this whole series, the topics and the presenters. So thank you, Hipaa. And thank you, Lomanto Provost Financial Advisors, for co-hosting with us. Our speaker tonight is Tara Ann Pleat, Esquire. She co-owns the law firm Walensky and Pleat, PLLC. She practices in the area of special needs estate planning and administration, traditional estate planning and administration, long-term care planning, and elder law. Tara is a member of the Special Needs Alliance, an invitation-only national network of leading attorneys dedicated to the practice of disability and public benefits law, where she serves on the board of directors and co-chairs the publications committee. Her bio is much longer than that.
Don't read it.
But thank you so much for presenting tonight, Tara. And Hipaa, I didn't know if you wanted to say anything else, but thank you all for being here.
I just wanted to echo, thank you all for being here. Thank you so much, Tara. I feel as though we're very lucky to have you here tonight. And this will be recorded so that we can share this information with the rest of the North Country. So thanks, everyone. And I'll leave it to you, Tara.
Thank you. So one of the first things that I like to do when I am giving any kind of presentation, whether it's in-person, Zoom, or otherwise, is just start off by saying a little bit about me, not professionally, but personally. It's timely for me to be giving a presentation about guardianship and alternatives to guardianship, because as some of you who are watching may know, I'm a parent as well as an attorney who practices in this area. And I have a 17-year-old son who is turning 18 on November 27th, who is on the autism spectrum. He has an Asperger's syndrome diagnosis along with ADHD and a couple of other comorbid mental health diagnoses. Today, he would be defined as somebody with autism 1, I think is how the new DSM describes it. But this issue, or the concept of guardianship and alternatives to guardianship, is not only an issue I face every day in my practice, but it's in fact an issue my son, myself, and his father are facing in our personal lives. And so it's timely for me, and it's also personally something that is impacting our family as we move on to, at least according to state law, our son turning age 18. It's often we find that when 18 comes, there is recommendations made to families that they seek out guardianship, whether it's to ensure that there's going to be continued dialogue with a healthcare provider, ensure that there's going to be continued dialogue with an educational program, ensure that there is a method for managing any funds that may be owned by or available to the individual who's turning 18 and may have a disability diagnosis. But I think it's important, and you'll hear as we talk about not only what guardianship means in New York, but what some of the alternatives to guardianship are. It's important for folks to realize that that's not the only answer. And a big part of the problem is that there is not, and I don't need to tell parents this, but there really isn't a one place you can go and obtain the information you need about what this actually means, what alternatives are out there, and how do you move forward off of this point, or how do you prepare for a person reaching the age of 18? So I know in prior programs, there's some discussion about special needs trusts and money management in that regard. So I'm not going to talk about that at all today, because I know that's already been covered. But sometimes people will look at trusts as an alternative to guardianship. For the purposes of today's discussion, what I'm talking about is the ability to advocate, represent, and support a person with their life choices and their life decisions, and the methods that we can look at as possibilities for for how to ensure that that continues after a person who has a disability diagnosis reaches the age of 18, assuming that disability diagnosis is a cognitive disability. All right. So with that, what are we doing a lot when we're talking about this? The primary reason why recommendations are made about guardianship are to ensure that an advocate and caregivers they're empowered. They have the ability to continue to participate in decision-making or perhaps make decisions if that's what the circumstances of the family is at that point in time. Many individuals with disabilities, however, don't like the label special needs. And in fact, today, I was meeting with a family whose son, 22 years old, has an Asperger's diagnosis. He came in and we reviewed planning documents for him. And I'm going to talk about those in a couple of minutes. And we looked at a special needs trust that his parents were creating for him that he wanted to understand. And he voiced that he doesn't like that label, special needs. He thinks that it's going to follow him for the rest of his life and doesn't want to feel trapped by it. And when you have kids who have the ability to use their voice in whatever way, the first thing we say to parents is you want to listen to that. You want to listen to, as best you can, take your mom and dad hats off and remember that this is a human being who has the right to make their own choices, presuming they've got the capacity to do it. And listen to those things that your children are saying to you. You know, a lot of times we say, we're mom and dad, we know best, and many times we do. I'm very guilty of that, given what I do for a living, but I'm also wrong sometimes. And I've learned over the last several years, both in working with families who have children that are similarly situated to my son, and working through the issues with my son, that we have to really address these considerations in a very meaningful way. Not everybody has the ability to do that. Not every child has the cognitive capabilities to have those kinds of conversations. They might communicate in a different way, but it's important to just keep in mind that that label, we throw it around all the time, but the individuals themselves might not like that label. Usually when we're doing planning for families who have children with disabilities or have special needs, it involves disabilities across the cognitive functional spectrum, right? Not just autism, not just Down syndrome, any number of different intellectual or developmental disabilities. And as many of you know, because of the diagnoses that our children have on a spectrum, right? Some of them are much better able to function in certain arenas than others, some of them less so. Every person is different. But we're recognizing that the planning that we're talking to families about in this regard is across the cognitive functional spectrum. And then when it comes to the decision-making for parents, and it really is a difficult one, what you're asking is your family member fully independent? And if the answer is no, now I'll say for a second, that sounds kind of crazy, right? We're talking about 18-year-olds. Not every cognitively typical 18-year-old is fully independent. I know 40-year-olds who are not fully independent. They don't have any disability diagnosis, but it becomes something that is much more focused for parents when they have kids turning 18 and they're worried about the transition out of the educational system. What do things look like down the road? Is the child participating in the OPWDD waiver program, which maybe provides some limited supports and services or limited self-direction dollars while the child is in school, but what's going to happen when they age out of school if they're not able to work? Who's going to provide advocacy? Who's going to deal with providing information to self-direction about reimbursement and finding staff? So if that's not something that the parents believe at this point in time their child can do on their own, I look at that and say, okay, the child we're talking about, the person we're talking about, I keep saying child because I'm thinking of people under the age of 18, are they fully independent? And if the answer is no, or there's some question about it, then parents generally have to wrestle with the issue of whether they look at guardianship or they look at something different. So what we say to everybody we talk with in our capacity as planning attorneys is that if you are over the age of 18 and you are a competent adult, you should be executing certain estate planning documents. And those documents are a power of attorney, a healthcare proxy, and a living will. I have a bullet point at the bottom of this that says supported decision-making. And I'm going to spend quite a bit of time at the end of this presentation talking about that. But for every fully functioning typical adult, we are recommending as a matter of course that if they don't have the documents in place that are identified on this slide right now, that they should, right? So what is the durable power of attorney? And these documents, I should point out, are alternatives to guardianship, not just for people who are turning age 18, but also for the older spectrum of individuals with disabilities. So the power of attorney document generally relates to property and personal decision-making. And when I say property, I don't mean your house. I mean assets that a person may own or income that they may have coming in from an outfit other than the Social Security Administration. It could be wage income. It could be income from an investment account. But the power of attorney relates to the management of money, financial decisions, and other personal decisions. Where is a person going to live? Can a rental agreement be signed on their behalf? That power of attorney is effectively a document that says, if at any point in the future, I lose the ability to make my own financial decisions or make my own decisions about where I should live, or I lose the ability physically to sign my name, that I'm appointing somebody to do that for me. Powers of attorney in New York are creatures of our state statute. There is a form that needs to be followed in order for that power of attorney to be considered a valid power of attorney. And there's a capacity determination that needs to be completed. The sort of the legal terminology is that a person has to have the capacity to contract in order to sign one of these things, a durable power of attorney. And that's not often well defined for people to know what that means. But I always say that the capacity to contract means you understand the rights you are giving to somebody else, what you are saying it is okay for someone else to do on your behalf, and what those rights relate to. So what do you have? What are the nature of your assets? What are the nature of the types of personal decisions, not healthcare, but other personal decisions that might need to be made that you want to delegate? The other thing you should know about durable powers of attorney are that while the intention is that they're utilized in the future, at some future point in time where a person no longer has capacity, they're actually effective when they're signed under New York state law. So if I have a durable power of attorney document where I name my son's father as my agent for healthcare or for durable power of attorney purposes, which means today he could go contact my bank and write a check on my behalf or take other steps on my behalf. Lots of times that piece doesn't get properly relayed to families who are considering that document, but they're effective when they're signed. How much property a person has, what the nature of their assets are, what types of questions they're being asked to answer. Maybe that's not quite such a big deal for a young person who's just reaching the age of 18 and they really don't have any of their own assets to speak of, and the expectation they're going to be living with their parents for a period of time. But it does give a parent the right to participate in certain types of meetings, in certain decisions and the like right off the rip. So that is something that I always ask people to consider. On the healthcare side of things, there's two principal documents that are utilized and a third that I don't have on the screen that I'm just going to mention. Healthcare proxies, right? A healthcare proxy is a document that relates to medical and other healthcare decisions. The current statute that governs healthcare proxies in New York simply says that a person can appoint one agent to make healthcare decisions for them if they become incapable of doing it themselves, and they can name a lineage of successor agents. But again, it's a choice that a person is making. My son may come into me and say, Mom, I understand what this is, but I don't want you making the decisions. I want it to be Dad. So I'm going to name Dad number one. And only if Dad can't act, then I'm going to name you to make healthcare decisions. So there's like a line of succession in those documents. I didn't say it before, but on the powers of attorney, a child could appoint both of his parents or a sibling and a parent or siblings or somebody else. The point is they're making the choice about who they want to provide them help if and when they need it. With respect to the healthcare proxy document, aside from the subject matter, one of the very big differences between healthcare proxies and powers of attorney is healthcare proxies are not effective when they are signed. They're not effective until an attending physician makes a determination that the person who is being asked to make a medical decision doesn't have the ability to make it. They don't have the cognitive capacity to understand what decision they're being asked to make and the ultimate consequences of that decision. And in that instance, then the physician may look to the agent named under the healthcare proxy. Back in 2009, there was actually a law passed that created something called an Act Now healthcare proxy. And that Act Now healthcare proxy is specific to the population of individuals who are supported through the Office of Persons with Developmental Disabilities. The Office of Persons for Developmental Disabilities was supposed to move forward in creating an actual format that can be utilized. And the Act Now part of it is what it sounds like, that my son Drew could name me as his agent under an Act Now healthcare proxy, which would mean I would be able to participate in the decision making right away, not after his attending physician makes the determination that he's not capable of making that decision on his own. So that is something that with the questions that are coming up about guardianship, and as we talk about the guardianship structure in New York, hopefully you'll understand why. But that's something that's starting to get a little bit more light again, because that is an alternative to going through the guardianship process. The other healthcare related document on the screen is something called a living will. That is essentially a statement of a person's intentions if they're in an end of life circumstance. If I'm in a persistent vegetative state, my brain is dead and my body is living and there's no reasonable hope of my recovery, and then I have a stroke or I have a heart attack or something happens that's going to bring on the end of my lifetime, that living will sets forth what my end of life decisions would be, meaning that I say that it is consistent with my wishes for my agent, my healthcare agent, to make a decision to withhold or withdraw life-sustaining treatment or not, that it's not consistent with my wishes, that they leave the plug plugged in indefinitely, if you will. But the point is, with all of these are choices that a person is making. I am able to say, I want Andrew Pleat to serve as my agent under my power of attorney. I want Andrew Pleat to serve as my agent under my healthcare proxy. I'm making the choice. So now I'm a competent 45-year-old adult. What happens if I don't make these choices? Well, if I lose capacity down the road, I suffer from Alzheimer's, Parkinson's, I get into a vehicle accident and I have a brain injury that affects my cognition, and I don't have these documents in place, then I may be the subject of a different kind of guardianship, a guardianship that's typically brought over individuals who are over the age of 18 and who had capacity during their lives, who didn't have an intellectual or developmental disability diagnosis. I don't get to make the choice anymore. A judge, after reading a petition that whoever brings it is writing about all of the things I can no longer do well or correctly because of my illness or my injury, that judge is going to make a decision about who's going to serve as my guardian. And it might not have been the person I would have appointed. In addition to that, it's an incredibly expensive process to go through when we deal with adult guardianships. I'm going to talk a little bit about those, but I'm going to spend more time focusing on 17A, which is the type of guardianship that we bring when we're talking about individuals with intellectual and developmental disabilities in certain circumstances. The only other document that I don't have identified on here as an alternative, but it is one, is something called a Hipaa Authorization. Probably all of you are familiar with that from your own interactions with your medical providers. But Hipaa authorizations are documents that a person will sign and provide to a healthcare provider that indicate who is able to receive protected medical information on behalf of a particular patient. A healthcare proxy, because the healthcare proxy is not valid until a person is deemed incompetent to make their decisions, doesn't give an agent named in a healthcare proxy necessarily the ability to access protected medical information. For somebody who's considering these issues with a person who's turning 17 years old. For my son, should we sit down and talk about these documents, feel comfortable that he understands them and he executes them? One of the documents we're going to want him to execute is a healthcare or is a Hipaa authorization, so that myself and his dad can continue to communicate with his healthcare providers, with a psychologist, and what have you, until he revokes them, which he will have the right to do when he gets older. And that's something that's scary for parents, and that easy revocation, that's also a part of all of these. When a person has a choice, when they're deemed competent to execute these documents, they're also competent to change them down the road. And that is something that as a parent can be really scary. Is there an ill-intentioned person that's come into their life that we don't necessarily trust? Are they too trusting? Are they too generous with what they have that we're fearful they'll get taken advantage of? There's a number of different things that we have to wrestle with in these circumstances. And when you layer perhaps not the best executive functioning or some wiring that creates a different decision-making tree internally for our kids, it can be really challenging to think through and talk through, but also giving credence to the fact that our kids are individuals and we want them to experience success. We want them to be as independent as possible if that is in the cards for them based on the nature of their disability. And so all of those things just become a part of the conversation. We often refer to ourselves as attorneys and counselors at law, right? And this is a place where we do a lot of counseling. And for me personally, it's just an interesting place because, again, we're dealing with this as parents. And I've learned a ton from my clients over the years. And I hope that I'm able to impart some of at least the thinking that goes on with that. As I start working with parents who are now facing this decision. So what is a guardian, right? We talked about agents, and that's generally who are appointed under a healthcare proxy, living will, and power of attorney. They're acting. You are proactively saying, I want you to stand in my shoes and make decisions for me if a determination is made down the road that I can't make decisions myself about my healthcare, about my money, about where I'm going to live, etc. A guardian is somebody that's appointed by a court to make decisions for those individuals who have been determined by the court to be unable to make decisions for themselves. As a general rule, there's guardianship of person and guardianship of property. Guardianship of person is healthcare, but also other personal decisions about where a person is going to live. So the two structures or the two paradigms don't necessarily mirror themselves. Person deals with decision-making for healthcare, but also deals with residential placement, what is an appropriate and safe living arrangement, and the like. Property strictly deals with money management, asset management, and decisions that are made for a person who does have assets. There are different types of guardianship in New York, and I identified them on the screen here. I'm going to spend most of my time focusing on Article 17A, but Article 17, you should know, is for guardians of minors, which are people that are under the age of 18. So if and usually where this comes up is if one parent passes away and leaves assets directly to a child under the age of 18. The other parent is their natural and legal guardian, but that doesn't extend to managing their property rights. They have to go to court, get appointed as guardian of the person for the child, and then manage their money in connection with oversight from the court. That ends at age 18. And generally, if families have children who are disabled, they have a disability diagnosis, they're not looking at guardianship of the minor. They would go right to Article 17A, which is where we're going to spend the majority of our time talking about guardianships. But Article 17A is a guardianship that is permitted under New York state law for individuals who have intellectual and developmental disabilities who have an onset date prior to the age of 22, or a person who has a traumatic brain injury, regardless of when that brain injury was acquired. So it could be after age 22. That is the population of individuals who can look to Article 17A guardianship for possible relief in having the ability to continue to participate in decision-making and advocating on behalf of an individual with a disability. Article 81 is the guardianship that I refer to as the adult guardianship statute in New York. That is the guardianship statute that would be utilized if a person was fully functioning throughout their lives and, as I said before, suffered illness or injury. And there's a very big difference between how those two guardianships are brought and how a family goes through that process. So 17s are, as I said before, for children under the age of 18. I talked about when families pass away, one parent passes away and the child receives assets. Often 17A guardians can be nominated in a will of a parent, and that happens sometimes. People think, oh, they're nominated, that means they're going to be the guardian. That's not what happens. There is a court proceeding that has to occur, even if an individual is named in a person's will for an Article 17 guardian. As I said before, it automatically expires when a child reaches the age of 18. And if there was guardianship of the property and that child, the guardian was holding money for that child, the guardian has to turn it over to that child on their 18th birthday. 17A guardianships, again, are for persons over the age of 18 with an intellectual or developmental disability. They're designated by court order in a surrogate court proceeding, and guardianship continues during the duration of the disability. There's no end date. And for most individuals who have an intellectual or developmental disability, right, they're organic, they don't go away. A person may adapt, a person may be able to become fully independent, but their disability diagnosis usually doesn't end. And so that is one of the biggest issues that people are facing in making decisions about guardianship for their young children who are approaching the age of 18. Recently, the Article 17A statute was the subject of a lawsuit involving its constitutionality. And really, when I'm talking to parents about this, when they say we think we need to get guardianship for our child, this form of guardianship is what I refer to as a fill in the blank, check the box type of proceeding. And there is actually, and I put a link to it in the slides, the New York State Office of Court Administration has a DIY website for applying for guardianship. And under the current law and why this statute has been under, I'll say under attack, that's not a good word to use, but I can't think of a better one right now, or has been the subject to challenge, is that the statute itself is effectively predicated on a person's diagnosis, not upon their functional capabilities. And advocates will argue that the proceeding operates under that old concept and doesn't recognize the capabilities of many individuals with disabilities. It just focuses on that diagnosis. The application, as I say, is a fill in the blank, check the box. It's a series of 10 questions that the petitioners, usually the parents, have to answer. There is a requirement that 2 doctors or a doctor and a licensed psychologist have evaluated the child and have determined that their disability is going to forever impact their ability to make personal and financial decisions, and it's likely to last the rest of their lives. Those physicians' affirmations are also fill in the blank and check the box. And in my experience, at least in the upstate courts, if you have 2 physicians' affidavits that both provide that indication, and often what happens in these proceedings is the court will appoint a guardian ad litem to represent the interest of the individual with the disability. So for example, if I were to bring a guardianship application over my son, Drew, the court in Saratoga County, Surrogates Court, would appoint a guardian ad litem to represent his interest. That individual in Saratoga County Surrogates Court, if Drew is living in my home, is going to be another lawyer who has taken some courses to be on a list to be appointed. Doesn't necessarily mean that person is going to have any understanding of disability, any understanding of Asperger's syndrome, any understanding of my son. But that's what happens. And if that individual who spends a few minutes with my family and my son says, oh yes, this seems like the right thing for Drew, most judges are going to approve the application for guardianship. And the main reason, aside from the fact that it is a disability diagnosis-based determination and not a functional determination. The main reason why this is so offensive to disability advocates and individuals with disabilities themselves is that this guardianship is plenary. And what that means, I always refer to it as an extension of your mom and dad rights. All those decisions you make about where a person lives, where they go to school, who their doctors are, who their friends are, you continue to be in the role of making those decisions, especially if that child is in your residence, who's living under your roof. The idea that you can void any kind of contract that child enters into, including the contract of marriage, right? There is a pretty significant deprivation of individual rights that comes under the Article 17A guide. And there is no, at least under the current law, there really is no mechanism under the law itself to tailor that guardianship. So for those of you who have kids who have been in the educational system and you've been through the IEP process, you know your child has to learn in the least restrictive environment, right? That is the goal in those IEPs, is to integrate and allow that child to have their education in a way that they're able to learn, but also not to unnecessarily segregate them in a restricted way. Article 17A guardianship doesn't have the concept of a least restrictive alternative built into it. So there is no requirement that there's a determination of capacity or that we looked at the alternatives of a healthcare proxy or living will. There are some judges around the state of New York who are requiring that. They're not, it's not in the statute that's allowing them to do it, but they're doing it because they see that Article 17A can be considered, or is in many instances, an unnecessary or overarching or overreaching deprivation of rights, especially for individuals who are, and I forgive me now for using this phrase, I hate it, my son hates it, but everybody knows what I mean when I say it, for individuals who are higher functioning, right? That is a consideration that has been starting to pop up when these guardianship applications have been brought around the state of New York. It's still my experience in the upstate courts. And when I say upstate, upstate to me generally means Albany North and West. And we have been a part of proceedings around the state, in the city, up in Clinton, Essex, Franklin, St. Lawrence. We've been a part of proceedings in a number of different counties around the state of New York. And there is a difference in philosophy and in practice, but the law is the same. And that guardianship being granted based on a diagnosis alone without any functional assessment is what has been the subject of a lot of criticism. The lawsuit itself was dismissed on procedural grounds, and what that means really is the constitutional issues, the issues about an undue deprivation of personal rights. The court never got to that. They were too busy dealing with what court should this matter be in, and whether or not the plaintiff, which was Disability Rights New York, an organization that I imagine many of you may have heard of, whether or not they had the standing to bring that proceeding in the first place. So the actual constitutional issues have not been resolved in a court in New York State or in federal court. And during that time that this court challenge was live, our state legislature was looking at ways at which they could modify the statute to bring it in line with being constitutional, and also more in line with Article 81, which I'm going to talk about in just a second. But when the case at the federal court level was dismissed, the legislature basically abandoned their concern because it was no longer pressing, and there weren't interest groups all over the place pushing for some kind of change. So just something to have out there. And when I talk with families about 17A, I do say this is the landscape. It's still a valid law on the books. It is still absolutely appropriate in any number of circumstances, but you need to be aware that there is a movement to challenge and to change this statute. But as it stands now, it's still something that a parent can do. We consult with parents all the time. And then when I tell them, you don't need a lawyer to go through this process. That's the other reason people like Article 17A, is that it's parent friendly, and it was intended to be that way. It's been around for 50 years. It's intended to be parent friendly, not to cost a ton of money and take a huge amount of time. But as time has gone by, a lot has changed in 50 years. There's a lot more progressive thinking about individuals regardless of their diagnoses, and that's changing the landscape. So I say that here just because that's what I say to my clients when we're talking about this. And so as much as we talk about guardianship, we really need to talk about those alternatives and determine whether or not those alternatives are a better fit for your child, and understand again that people have the right to make bad decisions. I make them all the time. I don't have a disability diagnosis where somebody can come challenge what I'm doing. They might just say, oh, well, that was a terrible decision, and that's okay. I have a right to do that. There's a concept out there that disability service providers talk about all the time, referred to as the dignity of risk. And that's becoming a more common theme in these discussions as well, which is the dignity of risk, right? If I'm going to be able to truly enjoy a success in my life, well, then I'm going to have to endure some failures, because how am I ever going to know what success is like if I don't endure a failure before it? If I make a bad decision, if there's an ill-intended consequence of me doing something without getting the appropriate permission from whatever agency is overseeing my needs, or from my parents, or for whatever it is. And so that concept is something we'll hear a lot more about in the mainstream as these issues regarding alternatives to guardianship and the concerns about this guardianship statute itself continue to be in the awareness of at least the disability community. And I would say, as time goes by, it's going to be in the consciousness of a lot more than just people like us who are in this community, because we have parents, siblings, friends, children who have disabilities, and we're worried about their care and making sure there's advocacy for them. Article 81 guardianship can be used for anybody with a disability. And as I said before, they're usually used when people were competent but have an unexpected change in capacity and they don't have a power of attorney or healthcare proxy in place. These are brought in Supreme Court, though, not surrogates court. And this is not a fill in the blank, check the box type of guardianship. You can absolutely not go through this process on a pro se basis or without attorneys. And if you do, the court is going to advise you to go get a lawyer and come back. And so this tends to be a much more expensive, protracted process that is filled with due process protections for the individual with the disability that do not exist in 17A. So part of the challenges that are coming to 17A are advocates looking at these two different tracks of guardianship in New York and saying it's so easy if somebody has an autism diagnosis or a Down syndrome diagnosis to get guardianship over here because they've got that diagnosis, and they're always going to have that diagnosis, and it's always going to affect some form of their decision making. And that's all you really need under 17A. And there's a guardian ad litem appointed, but that's different than being an attorney for the person who is alleged to be incapacitated. In Article 81, the court will appoint a court evaluator, somebody to be the eyes and the ears of the court to go interview everybody. They will appoint an attorney for the individual who is alleged to be incapacitated. In the 81 world, we refer to that person as an AIP. And I think it's important to talk to people about this because, again, downstate, what has been happening is if a 17A application is brought for somebody that does have some needs, but it's not to the court's satisfaction that they are an appropriate subject of an Article 17A plenary, your parents get to make your decisions for the rest of your life kind of guardianship, they will dismiss those guardianship proceedings and they will advise the families to go bring an Article 81. Very different process, a lot more expense, a lot more involved, and theoretically more protective of the individual with the disability because there is a least restrictive alternative element to Article 81. So often we'll see individuals signing healthcare proxies, but having an Article 81 guardianship of their property because the capacity to execute a power of attorney or to really understand the nature and extent of a person's assets. They don't have it, but they understand the concept of, if I can't make a healthcare decision, I want my daughter to make it. So I'm going to sign that document. And in that instance, I don't need a guardian of the person. So it's a very different process that a family goes through in that Article 81 guardianship. And 17A exists to make it easier for families who want to continue to have a voice and advocate. But as I've said now a couple of times, it's subject to challenge because of how broad it is. And because of the manner in which a determination that a person is in need of a guardian is made. So the advantages, right? What are the advantages to guardianship? It's a permanent appointment. Guardian's authority continues until further court order. Under Article 17A, one of the other criticisms that comes up is that guardianship, it can be, a person can have their rights restored. A guardianship can be rescinded, but under the current statute, the onus is on the individual with the disability to prove they're not disabled anymore in order to have that guardianship rescinded. Disability Rights New York has been associated with restoration cases around the state of New York, where individuals who at age 18, because of their disability, were the subject of an Article 17A guardian, and the child is now age 32 and doesn't think they need their parents involved in their life anymore, and they want to make their own decisions. And so Disability Rights New York has a group that is helping those individuals apply to the surrogates courts to have those guardianships rescinded. And again, in the current climate, those applications are being viewed a different way than they might have been 10 or 15 years ago. The thinking is more progressive, right? The people that came before us as parents have done such an unbelievable job advocating and causing there to be a much greater level of inclusion of our kids into mainstream schooling, mainstream society, mainstream communities, that progressive thinking is also making its way into the courts. The other advantages to guardianship is that there's court supervision over and review of a guardian's actions, principally with related to money, not so much with personal decision-making, but in some courts, Albany County, for example, they have a personal needs accounting that has to be completed every year by the guardian of someone's person in an Article 17A. Where do they live? How many times have you seen them? Is this guardianship still necessary? And part of that is just to make sure that if, God forbid, something happened to that guardian, there's a series of information that can be passed along to whoever is going to step in, whoever that standby is. Another advantage is that it's practically universally accepted by third parties, right? If I walk in to my son's doctor's office, if I walk into school, if I walk into an accessibility office at SUNY Adirondack, wherever I may go, and I bring that, I'm the guardian of his person and property, whoever I'm handing that document to has got to talk to me. If I've got to go to a disability service provider and I want information about my son's life plan, or some decision was made that I wasn't aware of, I'm his guardian, I have a right to know those things, right? Not because I'm a parent, because I'm a legal guardian. And so there is some advantage to that. But again, that has to be weighed against, am I in this paternalistic, overprotective place? And does my son really have greater capabilities than I might want to believe he has, because I'm worried about him getting taken advantage of, I'm worried about him getting hurt, whatever the case may be. But that practical universal acceptance is something that is important to a lot of families. The disadvantages, right? They vary depending on the nature and extent of the disability. For people who have severe cognitive limitations, for somebody who has, the academic level of somebody that's in first grade and, an IQ of 40, right? And I don't mean to be generalizing, but those are places where most courts are not going to challenge a parent bringing an Article 17A guardianship. In circumstances where a person has severe cognitive limitations, there really is not a lot of downside. And I always say to families, it's not like there is a registry, and there isn't. It seems kind of crazy, but there isn't a central registry where every single person who has a guardianship over them, it's out there, where a car dealer could go look up Andrew Pleat. My son and his dad have the same name. I apologize because I said Drew and Andrew. If that car dealer is about to sell a Jeep Wrangler to my son Drew and I'm his guardian, guess what? If he didn't really understand what he was doing, I can go in and rescind that. He doesn't have the capacity to contract. That's what that guardianship does. So for somebody who has severe cognitive limitations, again, there's very little downside because they're not going to be in positions where that is likely to be a circumstance they will encounter, where there's going to be a need to deal with voiding some kind of contract. For people who are higher functioning, who understand what's going on, the issues are more delicate. I wish I could have videotaped the conference I had today and shared it. I couldn't do that, obviously, because it's a violation of that family's confidentiality. But their son, you could tell that some executive functioning, some things, there wasn't quite a bridge between concept A and concept B, but boy, did he understand at a pretty high level what we were talking about and was challenging his parents' decisions about why they did things a certain way. Why was it different for them versus different for him? When we were talking, it was clear to me the concepts of funds, right? Having $10,000 to an 18-year-old kid who's never had any money in the bank, that seems like a ton of money that they could live on for a really long time. We all know that that's not the case. That's not going to get them through a year in even a credible residential setting in many parts of New York State. So you can see where there's great understanding, but also great limitation. And we're trying to balance that and what's the best way of balancing it. And that's part of these discussions we have about guardianship and alternatives. I mentioned before, the other disadvantages in 17A, it's plenary. Rights of a beneficiary are significantly restricted, the ability to contract, the right to vote. Article 81 requires a least restrictive approach, but it's significantly more cumbersome and expensive to initiate and get through the process. And I will also tell you that around the state, our guardianship courts are strapped, just like you guys probably are seeing if you are participating in any OPWDD programs that are not residentially based. And maybe even they are residentially based, but my experience has been this is a much greater issue with children that are living in their own homes in the community, or they're living with their parents and they're using self-direction. They can't find staff, they can't find people to provide support. I can get a budget, but I might not be able to find a person that I can hire to carry out what I've identified as needed in my life plan, right? That same thing is happening in the courts. They're overworked and they're understaffed. And so these processes are taking a long time. And the courts like the idea of alternatives to guardianship because that's less that they have to process. They don't have as many people to provide the level of oversight that's necessary. So there's all these different things at work out in the ether that are affecting the climate and what I will say progressive thought process, but some of it is out of a need also for those systems to be protective of themselves because they're drowning. For seniors who need guardianships, if there's no money as part of that senior's financial makeup, it's very difficult to find people who are willing and able to serve. And so the courts are looking for alternatives to guardianship as a result of that as well. And so again, just things for you all to have in mind in the background. Which route do you choose? There isn't a great answer to that. This decision is often one of the most challenging ones for the reasons that I've already talked about. For high functioning people with intellectual disabilities, this means weighing the risks and the benefits, right? How much property are at issue? Are family and friends close by? And if they're close by, is there a good relationship? Is the individual willing to have them involved in their lives? How would the person react to having a court-appointed guardian? 17A, under the statute itself, has a requirement that there's a hearing. Now, if you've ever been a part of them, in most courts, at least in the upstate courts, those hearings are not like what you see on TV. It's the judge having a very conversational type of exchange with the individual over whom guardianship is being sought. It's not intimidating, but it can be to say to somebody who's generally anxious or concerned about something like this, that you have to go into court, you have to talk to a judge because mom and dad are trying to make sure we can continue to advocate for you and take care of you. And depending on the court, depending on the guardian ad litem, there may be a broader discussion about what this guardianship really means. And that might be something that if you've got a higher functioning individual, they might not like to hear that from a court or from the guardian ad litem. So you got to think that if they have the capability of understanding that, then don't they maybe have the capability of looking at an alternative, like a healthcare proxy or a power of attorney? Whichever route is chosen, the key we're trying to get at the end of the day is to ensure that somebody is given the legal authority to help that individual navigate the service delivery system, navigate the healthcare system. And in some cases, if the person is not capable of making their own decisions, then making those decisions for them. The point I was making before about there isn't a central registry, right? It's not like my son Drew. If we were to go through and be successful in applying for guardianship, he wouldn't be walking around with a t-shirt on with a big G on it, right? Telling the world that he has a guardian. That's not how it works. The only people who would know would be the people we've provided our guardianship paperwork to in the court. So it is often talked about as the stripping of rights, and it is at its core, but a lot of it is in how families who go down the road of guardianship choose to use the authority they've been granted by the court. And so that is something that people need to be considering as well. And if you're counseling friends, if you are talking with an attorney about your own circumstances, you really want to be having this kind of dialogue and think long and hard about what abilities your child has, and what will they understand, not understand, what is in their best interest from your perspective. And then as much as you can, try to think about it from their perspective. And again, in some cases, I believe this decision is black and white, but in other cases, especially for children who have spectrum-based disorders where their abilities and inabilities are great in one arena, not so great in others, it's a much harder decision to come to. And you will often hear from many advocates almost like shaming kind of dialogue about it, like you should not consider guardianship because of A, B, and C. And I always feel like there's a voice of shame in that. And it makes me angry as a parent who also personally and helps clients navigate the service delivery system, which is not an easy process to navigate. And being able to pick up the phone and show you have legal authority is helpful at times when you're trying to get things done. And so that is a part of what I will often talk to families about as well. And it's also part of why I find the discussions that are now coming up about this concept of supported decision-making, which I'm going to talk about in a couple of minutes, something that you got to be aware of because it's coming down the pike, but understand that there are some practical difficulties that are going to be faced. So I talked about 17A as being user-friendly and mentioned that there is a DIY guardianship format. And the link is right here on the slide. The folks that are putting on this program have these slides. They can circulate them to you guys if they haven't, but that's a hyperlink. Click it and you're going to get to the court administration application documents. The application is filed in the surrogates court in the county where the person with the disability resides. And most surrogates courts, both upstate and downstate, have clerks that are trained to help families navigate that process. Again, because it is intended to be utilized without the need for counsel. The times where I see counsel needing to be utilized is when parents are divorced and they're not agreeing on who should be the primary guardian, or they're not agreeing on co-guardianship. And sometimes families just are afraid they're going to do it incorrectly and they want the peace of mind of knowing that they've got a professional helping them through it. But you absolutely do not need to have an attorney take you through that process. Then you get through the discussion of, okay, well, who should, let's say you've decided whether you're going to look at advanced directives or you're looking at a guardianship, who should be appointed? The appointment of a parent and a sibling as co-guardians or co-agents to serve simultaneously. I think that makes sense if the sibling's willing to serve in that role. It makes the transition of responsibility easier. We have done a number of programs on what we call transition planning 2.0. The initial transition planning is what you folks are all used to, right? A child is aging out of the school system. So now we're dealing with the transition from out of the school system into the service delivery system, from a minor to an adult, and what are all those things that happen at that point in time. Transition planning 2.0 is when we're talking about the ultimate transition, when a parent can no longer provide the free, continuous, ongoing support, advocacy, and oversight that they have been providing for their child's entire life, that they have done for free because they do that for their children. We think it makes sense if the family is comfortable and the sibling wants that role and they understand what that role is, to have them come on as at a time when they can learn from the parent, when they can see what's going on. I always say, have them attend a life care plan, have them be a real part of that process. So they understand if you're going to be asking them to step in. It's an important responsibility and it can represent a significant time commitment, right? And so depending on the individual's level of need, it's necessary that people have frank and open communications with the proposed guardians or agents. That's always the best thing to do. Sometimes people don't want to do that, but you want to know what you're signing up for. I want my daughter to, if she steps in and serves as an agent for her brother down the road. So those kinds of conversations about expectations, hopes, desires of both mom and dad, but also the individual over whom we're talking about. What does our child want, need? What do they want out of their lives? That's got to be a part of these discussions. So I know I'm at my hour already, which I can't believe, but supported decision-making, I just want to touch on for a minute, because there was, in June of this year, a supported decision-making statute that was introduced in the state legislature, and it was passed by the Senate. It wasn't introduced in the Assembly, but it's likely going to see the light of day again in the next legislative session. Basically, what supported decision-making is, and I've got a link on this page and a link on the next page to the two websites that really discuss what this project is. But Supported Decision-Making New York is a pilot project that was used to develop and distribute educational materials and to pilot this concept of supported decision-making for people specifically with intellectual and developmental disabilities in New York. It is meant to be an alternative to guardianship. The end result that the individuals who are a part of this want to get to is informing reforms to the guardianship law and advancing this concept of supported decision-making as an alternative to guardianship. Supported decision-making itself is really conceptually, and the way I describe this to families who are looking at it, and it's not a law yet in New York, it's not statutorily recognized, but it is a methodology where a person, me, parent of Drew, I'm not going to stand in front of him or in his shoes, not in front of him as a guardian or in his shoes as an agent, but rather I am agreeing to stand behind him and help support him in using his voice in whatever way he does that to make his own decisions about where he's going to live, who his doctor is going to be, what he's going to do for work, what kinds of supports and services he wants to receive. New York's approach to supported decision-making has been diversion. So there's two models. Or two groups, I should say. Diversion, right? Instead of guardianship, let's look at supported decision-making as an alternative. And then there's restoration. And I talked about those restoration of rights cases, and what Disability Rights New York and Supported Decision-Making New York are doing are they're having individuals go through this process where they sit down and they have long protracted discussions in whatever way the individual with the disability is able to communicate. It may be just like this, it may be in some different way, but to try to help parents rethink their role in supporting the child and allowing them to voice their own decisions, but agreeing to be part of, and you've heard this term probably through OPWDD in the past, a circle of support, different concept as far as supported decision-making is concerned. But the idea is the collection of individuals, the supporters, that the decision maker, the child, the individual with the disability is calling on to say, if I need to make a decision about this, Mom, I can call on you. Or Dad, I agree, I'm going to call on you, and you agree you're going to help me through this. And that's what this concept is. It is, I still have trouble defining it in a concise way, but it's an agreement. It will be under New York law, an agreement that is facilitated by people who have been trained through the pilot project, signed by the decision maker, the individual with the disability, and their supporters, whoever they may be, agreeing that they're going to participate in providing support to an individual using their own voice. The supported decision-making agreements in New York, what they're looking at, what they're going to define, I defined it as the big four. It's which areas a decision maker wants decision support in their lives, financial, healthcare, living arrangements, etc. Who is chosen to provide that support? And remember, it's the decision maker, the person with the disability making that choice, trusted persons in the decision maker's life. What kinds of support are you going to give? Are you going to gather information? Are you going to help somebody think through alternatives? Are you going to communicate decisions to others if that's what's being asked of you? And how is that support going to be provided? In person, FaceTime, text, group meetings? What's it going to be? All of those things are talked through. And the intention is you find the way that works the best for the individual with the disability. My concern about this, I love the concept. I always say in a utopian world where everything works perfectly. My concern about this is the practical implication of how it's actually going to be utilized in an everyday boots on the ground type of circumstance when a person is navigating the service delivery system or navigating the healthcare system. The roles I've defined here, and I don't want to take up too much time, the decision maker, I already said, is the individual with an intellectual and developmental disability. The facilitator is the person who, they're trained volunteers, but they're working initially with the decision maker to consider what kinds of decisions they want help making, who they want the support from, what kind of support they want, and how it's going to be provided, those big four. And they also assist the decision maker with communicating to their identified and preferred supporters. So they're part of that process in a very significant way. There's one philosophical qualification for the facilitator, according to the pilot project, and that is that you believe in the value of individuals with intellectual and developmental disabilities making decisions about their own lives. That you've got to believe that at your core, or the facilitator role is not for you. And then the formal qualifications are you complete a training, and then you've got to be able basically to function with Microsoft Office. There's also a mentor in the pilot project. They provide guidance as well as technical and emotional assistance and support to facilitators, as well as review draft supported decision-making agreements. Now, this is all in the concept that's being presented to the state legislature. How this will actually function will be determined by OPWDD regulations, assuming that this statute passes. The supporter, typically a family member, a friend, a paid service provider, that's selected by the decision maker, who agree to provide support as described in the agreement, and to refrain from acting as a substitute, right? You don't stand in front of, you don't stand in the shoes of, but you stand behind the individual and you help them communicate their choice, not substitute your judgment for theirs. And for parents, especially a parent like me, that is a tough concept, right? I know better because I'm mom, but maybe I don't know, or maybe I don't fully understand exactly what my son wants or needs. And the process of the facilitation is really a change in it's helping parents and supporters who are there, who care for and love the individual who they're concerned about providing ongoing advocacy for. They're changing their brain, they're changing their mindset. And that's really what that's about. I won't go through this, but this is the proposal. The link is there. So if you wanted to take a look at the bill, you could. My expectation is that what this bill says that's currently published is going to look a little different by the time it's actually passed, because it moved so quickly when it was introduced to the time of passage. As I said, introduced on June 1st, passed on June 7th. It didn't really get the light of day from an advocacy standpoint, and now it has, and there has been some advocacy with OPWDD. It's a program bill. This is an OPWDD drafted and supported bill. So that's something, if you're interested in looking at that, that's there. the proposal itself contains a presumption of capacity. And so there isn't a statement that says if you have an intellectual or developmental disability, you can't have these. In fact, it says the opposite of that. And that's a very clear and intentional statement to give individuals with developmental and intellectual disabilities the ability to choose this. It's not gonna necessarily say, oh, well, you have an intellectual disability, so you don't have capacity, which is effectively what the Article 17A guardianship statute says, and why there are so many people seeking to modify it. The language of this bill is clearly intended to undermine Article 17A and provide an alternative to that, where a disability diagnosis doesn't knock a person out of the box from being able to make their own decisions. The proposal sets forth the formation and the term of the agreement, provides expansive definitions over who can be supporters. It codifies the process, as I said before, which will be determined and defined by future OPWDD regulations. It sets forth the contents of the agreement and defines the legal effect of decisions made with support and the obligations of third parties to recognize those decisions. So if a person looks or sounds like they are disabled, and so a bank officer or a healthcare provider is not going, they're just going to do the paternalistic thing and say, I'm sorry, we can't take your decision. We don't think you have capacity. If that agreement exists, that agreement, based on the way this law is drafted, will require third parties, financial institutions, healthcare providers, service delivery systems, to accept the decision of the individual with the disability. And it will also give them some liability limitation for doing so. So all things that are happening right now, that it's important, because this will become, I expect over the next year or two, a viable alternative to guardianship, at least by statute. When I say at least by statute, it's because of my experience and my clients' experiences, and I imagine maybe some of yours, in navigating the service delivery system. You need to have, in my opinion, a formalized advocate and a seat at the table. And the supported decision-making agreements don't give you that as a parent. They don't give you a seat at the table. They give you a seat behind the table. And maybe that's good enough. But in some instances, it's not going to be, and that is just something to consider. As I said before, and part of this discussion is advising parents on guardianship in general, those alternatives to guardianship and advanced directives. And my personal thinking is if a person has enough capacity to understand this and sign an agreement, to sign a supported decision-making agreement, they might be able to sign a power of attorney too. So I'm going to give that some more thought. And then there's also the thinking that maybe these supported decision-making agreements are going to be used in concert together with guardianships or together with advanced directives to give that individual the greatest ability they can to, enjoy the experience of voicing their own decisions and having that ability. And so I apologize because I know I'm over by a couple of minutes, but when we talk about guardianship and the alternatives to guardianship, I think that you really have to have that broad spectrum of understanding. And that's really, I could talk about this for 7 hours. Nobody would stay on Zoom for that long, but there really are so many different considerations that I hope this gives you folks just some baseline things to think about and to know what those alternatives are and the different forms of guardianship that are out there in New York. I know there were a couple of questions maybe, and I don't know, Lisa, if you wanted to go through those or if because we're over, we're not going to. That's up to you guys.
No, I do intend to go through the questions. Thank you so much, Tara. You are just an absolute wealth of information. And I feel like I want to start by saying you had me at hello. When you started off your presentation saying something to the effect of, if your child has a sense of agency or a sense of self and the ability to express themselves, that we as parents need to listen. That really hits home for me as I have a child on the spectrum who's 20. I feel like, as a parent, I want to maintain so much control, but I'm discovering that as my child matures, that he has a lot more understanding than I give him credit for, and a lot more ability to understand himself and what he needs. So I just love that you started off that, instead of giving us this thought that because our child has a disability, he must go under my guardianship for the rest of his life. So I just thank you for that. Someone had a question about the slides. Yes, they will be available. You just need to ask Laura Carmichael, who is our executive director, to email you a copy of those. We had a question which says, does it hurt the case to wait to apply for 17A guardianship? For example, is there a lower chance of being granted guardianship at age 30 or 40 as opposed to applying at age 20?
And I would say in my experience, the answer to that is no. The reason why people generally will bring them at younger ages is because they encounter a barrier to participating in a decision or receiving information. But we have a large population of family members who are older, who didn't grow up in the same progressive mindset that we have at least been experiencing over the last several years. And they were of that generation where if a child was disabled, you just kept them at home. And they live in the residence, they're not part of any service delivery system. And then the parents are aging and now they need help. And this person doesn't have any formalized advocate. They don't have the ability to execute a healthcare proxy or power of attorney cognitively. And just to jump on that for a second, one of my colleagues today, a new paralegal in my office, she sat in on this appointment with this young man with Asperger's. And she said, well, who makes the determination that he has capacity to sign these documents? And I said, I do. I'm the one who's serving as a witness. Now, what I have no medical ability to do that. I'm doing it based on judgment calls and personal experience. And it's the same decision I make when I have an 89-year-old person who may be suffering from diminishing capacity, determining whether or not they can sign one of those documents. So if a person lacks cognitive capacity, whether they're 20, 30, 40, or 70, you can still bring that application, and it doesn't hurt the case to wait. And in some instances, I think that's the right thing to do. And I don't mean to bifurcate upstate and downstate, but it's the reality. I don't expect that when my son turns 18, his doctor is going to stop talking to me about his medication. I don't think that's going to happen. They know better than that. And that's been the experience of a lot of our families, is this is a child who needs to have an advocate. And what they might do is say, hey, Drew, is it okay for mom to be in the room? And he'll go, oh yeah, no problem. Or is it okay for me to talk to mom? Yeah, no problem. And so if we don't encounter that barrier, there's nothing pushing me down that road of going and getting authority so I can sort of force my way in. But again, the individual has to have the capability of understanding what the doctor's asking them. So the short answer to the question is, my professional opinion is no, it doesn't hurt the case to wait. And especially and I say our kids, right? Kids on the autism spectrum. My son has progressed an unbelievable amount in the last 3 years. I don't know what he's going to be 3 years from now. Like, he could make unbelievably huge strides that I thought 3 years ago he was never going to make to where he is now. Our kids have a different wiring. They have an ability to adapt, some better than others, but I'm not going to jump into the guardianship. I'll tell you, like, the decision Dad and I have made is we're not going to do it unless it's forced on us. We're not going to do it. I'm going to have them sign a healthcare proxy because I think, I didn't say it when I was going through the slides, the capacity to sign a healthcare proxy is like, you have to be alive, you have to have a heartbeat, and you kind of got to know who the people are that you're thinking of asking to help you make your healthcare decisions, or make them if you can't. Very low level of capacity. That it's very different than having the ability to understand, the nature and extent of rights you're giving to somebody else and obligations that the obligations that those individuals have, and that's the level that you need for a power of attorney. But our intention is to wait. And if we get to a point where we need access to something that we can't access, then my preference for my son is going to be, we look at the power of attorney road, and I have to have somebody other than me make the determination that he is competent to sign it. I think he is, but I obviously can't make that determination. I need somebody else who's objective. to do it. And he may say, yeah, I know exactly what this is, and I don't want her dealing with any of my stuff. And that's his right. And that's the other thing, Lisa, to your point, like we have to think about that stuff. We think we know best, but our kids may be sick of us interfering and wanting to try to do things on their own. And we got to give them the ability to do that.
Yes. Okay, thank you. So I just want to confirm, I think I heard you say that as a parent, we should be getting a power of attorney, healthcare proxy, living will for all of our children, not just children on the spectrum or with a disability.
Everybody who is a competent adult over the age of 18 who can make a choice. Typical kids don't think about this stuff, right? It's parents who have kids going off to college who are worried about, interacting or being able to pick up a prescription, stuff like that, or they're going overseas. That might trigger their thought process a little bit more. But no, it's my advice is if you are a competent adult over the age of 18 and you can choose who you want to be in that role today when you're right-minded, if tomorrow you get hit by the proverbial bus and your cognitive functioning declines, do it. Far less expensive, and you're choosing who it is. If you don't get hit by the proverbial bus and your life changes, and 10 years down the road or 5 years down the road or a year down the road, you want to modify those documents, you can. They're freely revocable. And they're fairly simple to do and far less expensive and demeaning than I shouldn't say far less expensive and less demeaning than a guardianship proceeding, where all the things you can't do become the subject of how decisions are being made over who is going to be the person that makes your financial decisions or makes your personal decisions.
Okay, thank you. And one more question. Someone writes, my child has a very severe disability that impacts his ability to go through life without one-on-one support 24/7. Without a science miracle, he will continue to require maximum supports throughout the rest of his life. I believe that guardianship Article 17A would be the correct avenue for guardianship for myself and my ex-wife. Is this all we have to do to provide guardianship care for our son? Are there decisions we will not be allowed to make to care for him, keeping in mind that he's not capable of making any decisions now and moving into the future? It's
a really good question. When you proceed under Article 17A guardianship, and if your belief as a parent is he needs support, can't do anything on his own, needs 24/7 assistance, I would be saying to you, if you were in my office, apply for 17A guardianship. When you apply for it and you are appointed as guardian of the person and guardian of the property, you have plenary decision-making rights. You will be able to make end-of-life decisions. You will be able to make everyday decisions as it relates to residential care, finances, and et cetera. You said, are there decisions we will not be allowed to make to care for him? I'm not sure I know what you mean with respect to that, but, and is this all we have to do to provide guardianship care for our son? I don't know if your child is receiving any kind of supports and services through the Department of Health or through the Office for Persons with Developmental Disabilities, but you may be able to access those if you are not already accessing them. But the short answer, I think, to this question is yes, all you would need to do to ensure that you are capable of making every decision on behalf of your child is an Article 17A guardianship. The point I was making before is just because you get it doesn't mean you have to make all those decisions if you have a child that can do some things on his own or her own. But here, if your child is not capable of making any decisions because of their cognitive capacity, and that is expected to endure through his lifetime, then you would become 17A guardians and you would be the voice on a going forward basis. And that is all you need to do.
Wonderful, thank you. I hope that answered the question. I thought that was great. I don't see any more questions in the chat. Oh, wait, take that back. Someone writes, thank you so much for the information. That's really useful and helpful. And then another question, power of attorney can be completed with the assistance of a notary or witnesses as long as they can answer the questions asked about the areas they want the person named to control. Is that correct?
It is, but I will tell you that, well, it actually needs, it's not notary or witnesses, it's notary and witnesses. So you have to have a notary public and you have to have two uninterested, unrelated witnesses. Nobody who is being appointed in that document as an agent can be a witness to it. And what I would caution is that document is something that really you should, and this is not a plug for me as a lawyer, but it's a creature of statute. And there are the forms, if you will, that are out there sort of in the ether, unless you're getting it from the New York State Bar Association website. You can't be certain that or you're getting it from an attorney who you could sue if they did it wrong. You can't be certain that what you're getting is statutorily accurate. There's a lot of stuff out there that's not accurate. And the power of attorney law just changed in June of 2021. So the format changed recently. And so that's just stuff to know. But yes, two uninterested, unrelated witnesses and a notary, and the notary and one of the witness can be the same people. And that document is you go through and you initial the authorities you want people to have, or you don't initial what you don't want them to have. And yes, same, the healthcare proxy needs two witnesses as well. Same concept, uninterested, unrelated, not named as an agent in the document.
Okay. Tara, thank you so much. This was amazing. You obviously know your stuff, and I'm sure that we will be sending some of our constituents to you for further information, because you really know your stuff. And I really appreciate that you took the time to put together this wonderful PowerPoint and explain it all to us in a way that was understandable. So I appreciate that.
I appreciate you guys having me. Hopefully everybody found this stuff useful, and there's just a lot. There's a lot of things to consider. So thank you for giving me the opportunity to talk to you folks. I appreciate it. Take care, everybody. Thank you.
You too. Have a good night.